Recently, the issue of revising the Public Security Administration punishment law has become a public issue again. Several legal gurus, including Che Hao, Lao Dongjian, Zhao Hong, and Tong Jiwei, have joined forces to publicly oppose Article 34 of the draft amendment to the law. The reasons are probably that the relevant concepts are vague, may stimulate populism, and are not based on the protection of legal interests. On the basis that interference with personal freedom is not justified, this statement may not be easy to understand for those who are not majoring in law, but I am extremely sorry, the exact words are like this. In fact, the translation into human language is very simple, only to protect certain legal rights. Only the law can control people's interests, it may lead to random arrests of people in law enforcement, etc. What is a fuzzy concept? These reasons are actually very easy to refute. However, it seems a bit too much to ask a few legal experts to retake the philosophy of language course on issues such as whether the concept is vague. According to the philosophy of language, there are no inherently vague or precise concepts. The meaning of all words depends on the rules and consensus of a community when used. For example, ordinary Chinese people do not have too many differences in their understanding of what a knife is, and the difference between a knife, a sword, and a dagger is also very clear to everyone, and ordinary Chinese people with no education generally do not get it wrong. But if anyone wants to give a precise definition of a knife, it is not an easy task. If you have to say that the knife is curved and the sword is straight, then is the kitchen knife curved? If we have to say that a single edge is a knife and a double edge is a sword, then why are there so many single-edged daggers? Why is there a single-edged sword? What's the thing about Japanese kendo that counts swords and swords? So, what is the precise definition of a knife? Or can you define exactly what a knife is? However, does this prevent us from using the word knife in our lives? In fact, the same is true for a large number of so-called precise legal terms. At first it seemed like there was a precise definition, but as I started to use it, I found that this was not the case anymore. For example, property rights are legally stipulated as the right to control things. However, what is a thing? Are invisible objects such as magnetic field frequency bands objects? Are virtual properties objects? How can a debt pledge be used within the security interest? Etc. Therefore, property rights are not precise and this concept should be abolished? On such a simple question, Wittgenstein, who entered the lyrics of Dao Lang some time ago, actually made it very clear, the meaning of all words lies in their use. No words are precise or imprecise. The key is whether the speaker and the understander agree on the actual application. In fact, the vast majority of Chinese people have a relatively consistent understanding of terms such as the Chinese national spirit and Chinese national sentiments. They are Chinese. If they really agree and love the Chinese nation, how can they not feel if their national sentiments are offended? For those who do not identify with their Chinese identity in their bones, they are certainly not so sensitive if anything offends the feelings of the Chinese nation. Why those professors who spoke feel that the concept of Chinese national sentiment is vague is probably not difficult to understand by searching their usual remarks on Baidu. Of course, they may not really know, or they may pretend to be confused. Although the views of several professors are very refuting at the academic level, don't accuse me of why I don't write academic articles to refute. How can a legal journal platform in the hands of certain groups give me a fair chance to refute? However, another important question I want to discuss today is, do law professors really have more say in legislative issues? This is actually an issue that the broad masses of the people, and even government workers in charge of legislation, can easily be deceived, and it is an issue that needs to be clarified. To the position of jurists, legislators or interpreters. Here I need to popularize knowledge about law to everyone. Note, this is not a popularization of law. In fact, modern jurisprudence originated from analytical positivist jurisprudence. It doesn't matter if you don't understand or remember the name. Austin, the originator of analytical positivist jurisprudence, distinguished law from legislation. Law should only study law in reality, leaving legislative issues to ethics. What does it mean? From now on, legal studies should take the laws established by the country in reality as the research object, and how to legislate is actually not something that you, the legal scholar, are competent or arbitrary. The reason is actually very simple. In Western concepts and decentralized structures, legislation is actually a political matter, a matter related to national governance, and a matter for parliament and the government. How to legislate and what kind of laws to enact, the final consequences must be borne by the government and parliament. Can you, a legal scholar, bear this? Do you, a legal scholar, know more about political issues and social governance than the government, parliament, and executive departments? Are you more responsible for relevant decisions? So what do jurists do? Study the laws that have been formulated or the laws that exist in reality, and abstract and refine the contents of these laws to make them more systematic and better applied in reality, etc. Some scholars have summarized that this is the transformation of legal scholars from legislators, makers of basic rules, to elaborators, mainly discussing the application of law in reality. Therefore, the German legal scholar Karl Lenz said something to the effect that respecting the laws enacted by the country in reality is a virtue that jurists should have. In other words, you jurists should not have a resentful attitude towards the country and say that this is wrong with the country and that is wrong every day. The laws enacted by the country need your help to be implemented properly. Of course, this does not mean that legal scholars cannot participate in legislation. In fact, there are still many things that lawyers can do in legislation to help. For example, how to use terminology to express a rule so that it is more like professional legal language, for example, clarifying the structural issues of the legal system and eliminating legal provisions. Contradictions, for example, discover and clarify possible contradictions and conflicts between this law and other previous laws, and eliminate relevant contradictions, etc. All in all, the main job of jurists in Western society, especially after the 20th century, is not to participate in legislation. And the main academic research and knowledge accumulation are largely not about how to legislate. Legislation is a matter for the government and parliament. Of course, in some fields, jurists will still provide feedback and suggestions to the government or legislative bodies based on some problems that arise in the actual operation of the law. However, this kind of feedback is often more technical rather than changing existing legislation from the perspective of a conceptual system. However, our professors did exactly the opposite. What they raise is not a technical issue, or even if they are questioning a technical issue on the surface, their attitude is not to help improve the legal professional aspect, but to directly question the conceptual system of legislation, that is, a value issue. 3. The value preferences of legal scholars are not necessarily better than those of ordinary people. Regarding what kind of value a law should realize, to be honest, this should not be a question that jurists should discuss, but it is the question that Chinese jurists are most keen to discuss. The reason is simple. At the end of the 19th century, Nietzsche killed God. From this time on, which value is better than other values has become a difficult problem to judge. The field of value itself advocates equality and diversity. Therefore, Max Weber later emphasized that scholars should be value neutral in certain fields and not impose their own value preferences on others, because you cannot prove that your value is better than others. It's like, some people like to eat spicy food, and some people like to eat sweet food. If you eat spicy food, you must say that spicy food tastes better than sweet food. Can you prove it? If you can't prove it and still force others to accept it, aren't you sick? However, some Chinese jurists have a habit of emphasizing that their own value preferences are superior to those of ordinary people. For example, criminal lawyers place special emphasis on the protection of human rights for criminals and suspects, and the abolition of the death penalty. The question is, overprotecting the human rights of criminals and suspects makes the punishment fail to serve the purpose of punishment. Will it have a negative impact on social security and the overall social order? If the human rights of criminals and suspects are overprotected, how can the human rights of victims be protected? On this issue, the general public and victims will probably have different value demands than criminal lawyers. So, why do you, a criminal lawyer, say that your value preferences are superior to those of the public and the victims? Don't listen to those scholars fooling around. Regarding the issue of value differences, in fact, criminal law scholars have never really successfully demonstrated that their own value judgments are superior to others. Academic circles in Western society have long denied the idea that scholars' value preferences are inherently better than those of ordinary people. Western academic circles have roughly put forward 3 ideas to solve the problem of differences in legal values. One is Alexei's legal argumentation idea. This idea sets up a large number of procedural regulations to require scholars to conduct value arguments. However, it is estimated that no one in Chinese legal circles can actually complete the argument in accordance with this requirement. One is Perelman's persuasion idea, which basically means that you scholars can have your own value preferences, but you have to convince the people to accept them, rather than force them to accept them. One way of thinking is Habermas's discussion idea, which means that on value issues, scholars need to discuss with the people, which is rational discussion. Habermas put forward the consensus theory of truth on the issue of value, that is, in the field of value, only consensus based on rational discussion is the truth. Scholars' own preferences mean nothing. It is estimated that many legal scholars do not read these basic methodological books very much, or do not understand them after reading them. Some scholars in my country's legal circles currently like to use their own value preferences to forcibly suppress, rather than persuade, the public. If the public has different values from theirs, then they are completely populist and legally illiterate. This is actually a kind of value autocracy. So, what should we do when we need to consider choosing between different values when making political decisions such as legislation? Weber provided a simple and clear idea, that is, looking at the consequences of political decisions based on a value in the past. Because no matter how exaggerated you are about your value preferences, if it is implemented at the level of social governance and ultimately leads to bad social consequences, then there is something wrong with your value indoctrination. The reason is very simple. Which is more important, your value preference, or the healthy development of society? For are the knowledge reserves of certain jurists really qualified for legislation? So, do we, the experts who express opinions on the public security management punishment law, care about real social governance? Do they have knowledge about security management? Can they be responsible for the consequences of social security? I'm afraid neither can. In recent years, my country's legal circles, especially the criminal and civil law circles, have been mainly engaged in something called dogmatics. In fact, the jurisprudence of Western countries is mainly based on dogmatics, but they follow the existing laws of the country and explore the conceptual system and how to interpret and apply it. But our country's dogmatics is rather weird. They don't think much of China's own laws. They regard Western legal provisions and conceptual systems or related theories as their ancestors. They use this to compare Chinese laws and find that everything is not pleasing to the eye, so the sky-high price calls for the revision of this law. As for the consequences of the actual operation of the law, frankly speaking, it is basically not within their field of vision, even if they sometimes do so-called research that is insignificant. The jurists trained by this kind of doctrine generally understand the conceptual system of law, foreign legal provisions, and legal theories very well. However, how much do they know about China's reality? How much does their knowledge reserve have to do with China's social governance? As for legislation, we must understand China's reality, understand China's social governance, and be responsible for China's social governance. In this regard, can these scholars bear the relevant responsibilities, or have they ever thought that they should bear the relevant responsibilities? They have no knowledge base in this area and cannot bear the relevant responsibilities. So, why should they have more say on legislative issues? Therefore, regarding the revision of the public security punishment law, instead of listening to the deceptions of these scholars, it is better to listen to the voice of the general public, because the Chinese people are the ultimate bearers of the consequences of legislation. Instead of listening to the deceptions of these scholars, it is better to listen to the opinions of the frontline public security police. Opinions, because their actual knowledge about social security is much richer than those few legal scholars. Of course, this does not mean that legal scholars cannot express opinions on legislative issues. This freedom of speech should still be advocated. However, whether it is the legislative body, the government, the media, or ordinary people, do not take their speeches too seriously, and do not be superstitious that because of their status as jurists, they have professionalism in these fields authoritative. The knowledge base of these jurists has little to do with social security issues, and their value demands are not responsible for social security. So, how to amend the security-related penalty law? Why should we listen to them? Enlightenment, argument, or negotiation. Also talk about the relationship between Chinese jurists and the public. Abusing the power of speech, the core of Sichuan University student Zhang's mistakes. Jia Jian, experts on the narrow-eyed incident and the public, who has the final say on what constitutes a good cultural work. Abe's death and the ethical confusion of China's elites.